Thanks again for everybody that's joining us. Looks like we've got about 73 members here for this presentation. Welcome, Stan. Thank you so much for joining us today. Audio looks good, video is good. So with that, I will let you get started. I know we're all excited to hear what you've got to say about our new lease that you worked very hard on, and we greatly appreciate that and the partnership we have with you, and what you have to say about our current legal environment. Thank you.
All right. Hey, thanks for having me. I'm Stan Masters, and I've been had the pleasure of representing the Missouri Self-Storage Owners Association for about 20 years. So I've spoken to the members many times, although I think this is the first time I've done it via this kind of technology, which is a challenge for me because normally I stand in front of you with a paper handout and a yellow legal pad and we talk about the law. But thanks to COVID-19, like many of you, I've had to work from home, and it's caused me to have to learn to use the new technology. So I've said all of that to say, I may not be as smooth with this as many people are using the technology, but I will do my best. Also, as you always hear from me, I need to start with the disclaimer, which is that we're going to be talking about the law today, but what I'm giving you is not legal advice. It's rather for educational purposes and will not substitute for you talking with a lawyer about a particular issue you may have. And that's simply because in this context, I can't speak with you confidentially, ask the questions I need to ask in order to give you specific legal advice. So we'll talk about the law. Hopefully you'll find some things that you can find useful. And if it poses something in your mind that you need to follow up on, you can consult a lawyer, or you're welcome to contact me. I'll give you my contact information at the end of the presentation. So let me start here, and here's the first challenge. I need to get some information up on the screen for you so you can follow along today. So hopefully I have been sufficiently trained that I can make this work. So bear with me.
Steve and I are right here with you if we have any trouble. So.
Okay, trying to get it on the screen. Do we look like it's coming through?
It's not coming up yet. You're using the bottom share screen button, correct?
And that is correct.
Okay, and it should, once you click that button, it should ask it, well, it won't ask you, but there'll be some screens come up and you have to click the presentation screen that you want to show.
Okay.
Make sense?
It does make sense. Hang on. I'll try it one more time. Okay. It is there. And let me call my trusty assistant here to see if we can figure out what our problem is.
That always helps.
While you guys are working on that, we had one of our members, Dale and Ray Stoecklin, asked that we mention the passing of Dale Jordan back in February. I did not have the pleasure of meeting him, but I've learned, oh, there we go. We learned his passing a couple months ago, right after one of our board meetings. I know he was a asset to our association and the self-storage owners in the state. So thank you, Dale and Ray, for bringing that to our attention, and our prayers are still with his family. All right, Stan.
Are we looking good now?
You look great. Thank you. Okay,
let's get started then. Well, the first thing up today was supposed to be an update on COVID-19 as of today's date. About a month ago, we circulated to the members some information as of March the 27th, and it has been something of a moving target ever since, trying to get you the most recent information because the governor keeps updating his orders. But let's go through it. And I went to bed last night expecting information about the governor's order and woke up this morning to discover it. So my slides may be a little bit out of date, but I think we can talk through the primary issues. At this stage, of course, we have the governor's stay-at-home order, which remains in effect through May 3rd. At the time I did this, we didn't know if it would be extended. Of course, now we know that based on his prediction on April 17, he was going to implement the first phase of what he calls the Show Me Strong plan, which was a plan to get people back out of their homes and get businesses up and running. And sure enough, last night, the governor issued that the rules and regulations for that first phase of the Show Me Strong plan. This first phase will be in effect from March the 4th, next Monday, through May 31. As of right now, it basically is going to run through the month of March. And the governor, let me just suggest this to you. I'm going to tell you what's in that order and how it affects us, but you may want to read it for yourself. And to do that, I recommend you go to governor.mo.gov, www.governor.mo.gov. That'll bring up the governor's website. There will be a press release there dealing with phase 1 of the Missouri or the Show Me Strong program, first phase. When you get to the bottom, if you go to the bottom of that press release, there will be a link to the order itself, which is relatively brief actually, and then another link to something called additional guidance. Let me highly recommend that you look at that additional guidance link because there's a lot of really good information in that link. So what does the governor have on tap for us? Well, he told us, if you look at his press release, this is designed to gradually reopen business in the state, to allow citizens to return to economic and social activities, that all businesses can be open provided they maintain the proper social distancing requirements. He said, and he warned, expect your business to look a little bit different than usual for a while. And he also warned us that this plan is flexible to reflect changing situations. So if, God forbid, we should have an uptick in cases again in COVID-19, this could be adjusted to tighten the screws down. On the other hand, if we continue to show improvement in the Show Me state, then this may be loosened and make it easier for us to do business. So specifically, what does the governor have in mind? Well, for businesses, the basic rule is you must maintain 6 feet between employees, 6 feet between employees and customers to the fullest extent possible. There is an exception, of course, for some types of jobs, some types of businesses where you have to get closer than 6 feet to take care of a customer. So think, for example, of your dentist, for example. Someone like that could be closer. Shouldn't really be an issue for self-storage, so we should probably look at keeping those 6 feet between employees, if possible, 6 feet between employees and customers. And it specifically suggests in the governor's order that includes customers who are standing in line. Now that could be an issue for us if you open the doors and you've got several customers trying to get into your facility.
Absolutely.
Please.
Well, hey, Talking Ray, that's those are great connections, and but if we have our fall show, stand that.
Okay. I thought that was the question, but apparently it was not. The other thing you need to be aware of is that there is a rule that requires businesses in retail sales to abide by some additional rules. And you may say, well, we're a service business, so it doesn't really apply to self-storage, except that many of you sell locks and boxes and packing supplies and tape and things like that in your front office. Well, that would be a retail sales. So you would have to take some steps to limit the number of customers that you have in your office area at a particular time. Now, this is a change from the governor's earlier orders. We used to have this kind of a restriction, but it related primarily to those who were selling food. But now it says all retail sales. So 2 things you need to know. Number 1, how big is your retail space, which would basically be your office? And then what does your local fire code or building code say about your maximum occupancy? Those are the 2 drivers for this. So if your office space where you sell supplies is less than 10,000 square feet, then you should not have more than 25% of your occupancy limit in your store at one time. if your facility, your area where you sell things is 10,000 square feet or greater, that number is 10%. So you need to, it's really a restriction on preventing too many people being in your sales area at one time. Now, the good news is employees do not count into that total, nor do vendors. So it's primarily aimed at customers. But please be aware of that. And by the way, if you're in a location that doesn't have a fire code that tells you what a maximum occupancy is, again, if you'll go to that website, the governor's website I mentioned earlier, and go to that additional guidance link that I told you about, it will tell you how to calculate it if you don't have a specific standard in your area. So, but here's and also we are encouraged, not required, but businesses are encouraged in the state to prepare to implement basic infection prevention measures if necessary. Again, if this thing should take a turn and our numbers of COVID-19 start to tick up, then we might be called upon as business people in the state to think about things like protective equipment, mandatory temperature checks for people coming into the office, those kinds of things. It doesn't say we have to do those now, but rather we should be prepared if that happens in the future. Also, it encourages us to have a plan if necessary to handle those things. We're also encouraged to modify our workspace to permit that 6 feet of social distancing, to allow a phased return to work for employees or split shifts, again, so we're minimizing the number of people in our facilities, encourage people to continue to work from home when and if that's possible, and limit the use of common areas for our employees. Again, the point being here, we want to try to keep as few people as possible in the location and keep them as far apart as we can, or at least more than 6 feet. So that's what we're being encouraged to do. The 6 feet, of course, is mandatory under the governor's order. But here is the critical thing that's been a part of the governor's order since the first day he issued a stay-at-home order, and that is local authorities can still implement different rules consistent with the order. And those rules can be more stringent than the governor's order. So the governor's orders have always been the minimum standard for the state. But as I said, it can permit local authorities to set stricter standards, and many of them have. So for example, here in Kansas City, we have a battle going on between the governor, who wants to open the state up to business on May the 4th, and a mayor who wants to keep things actually with non-essential businesses closed through at least the 15th of May. Well, under the governor's order, if you have a self-storage facility within the city limits of Kansas City, Missouri, you're going to have to abide by the Kansas City, Missouri order. And this whole situation kind of turns our usual way of thinking of things on its head. We usually think that the federal government trumps the state trumps the county trumps the city. When dealing with these health issues related to COVID-19, we turn that on its head. So when you try to look for what orders are applicable to your business, you start with your local city or town. If they have nothing, you look at your county. If your county has nothing, you look to the governor's order. And frankly, the federal things, from what I've seen, mostly apply in situations where there may be federal loans or things like that involved. So that's the way you have to look at things. And what you'll find right now is you have some cities like Kansas City who are saying, nope, we're going to keep everything shut down until some point in the future. You have others like our local county, Clay County, Missouri, which is saying we're going to open on the governor's time frame, but the requirements for businesses are more stringent than what the governor has set forth. So you're going to have to know what those local things say. So the two takeaways at this point are, number one, these orders can change very quickly, and you're going to need to stay on top of that. Second, you've got to know what your local authorities require, because those are the folks most likely to show up at your door and ask you about what you're doing and why. And there are some penalties involved if you run afoul of those orders. In our locality, for example, it could be a fine of up to $500. Also a threat of imprisonment up to 6 months. I think that's unlikely, but certainly a fine could follow. So is self-storage an essential business? I've been getting that. That's a less important matter, but interestingly enough, under the governor's order from the beginning, his stay-at-home order didn't matter. Non-essential businesses could stay open as long as they followed the proper distancing and limiting on the size. Please note, under the governor's order that we discussed just a moment ago, that's applicable in the month of May, interesting, there's no limit on the groups of 10 or less. You can have more depending on where you are and what kind of capacity you're entitled to, but the 6 feet remains in place. Some local orders, as I said, are requiring non-essential businesses to close, but most of those orders, in fact, none of the orders I've read so far mention self-storage by name. So what do? We're not mentioned. It's a gray area. Well, what I have noticed is there is a little bit of play in the joints with these various orders on the definition of essential business. So if somebody were to challenge you, if you were open, you've tried to comply with the orders, you've concluded you are an essential business, and somebody were to challenge that, then your arguments may look more like the 2 that I mentioned before. Well, self-storage is like an essential business such as. So if you were to look at the federal definitions from the Department of Homeland Security on what constitutes an essential business, they mention warehousing. Well, self-storage is kind of like warehousing, and therefore we should also be considered an essential business, and therefore able to open regardless of what the orders may say. Another one is that self-storage supports essential worker businesses like. I mentioned Kansas City, Missouri, which has a pretty stringent closing order for non-essential businesses. But there is, in the definition of what's essential, businesses that supply products so that people can work from home. Well, it may well be that if I'm going to have to suddenly work from home, I may need some of that furniture I have stored in my self-storage facility, or I may need some place to put the files that I don't have room for at home. In that sort of way, you would say, well, self-storage is supporting essential work. Others of you may have, as customers, businesses that are by definition essential businesses. That could be, legal or accounting firms or hospitals or doctors' offices who store records with you. It could be pharmaceutical salespeople who store inventory with you. It could be the local plumber who keeps his supplies of pipe and fitting and that sort of thing in a self-storage facility or unit at your facility. Well, then you have a pretty good argument that I'm an essential business because I'm supporting other essential workers or essential businesses. Keep in mind, if you run into any kind of an issue, it's mostly going to be enforced by some local officer who's going to be making a judgment on the spot. So what I would recommend is, it's sort of like when you're driving too fast on the highway, you pass a police officer, you don't make eye contact. Here I would just suggest to you, keep your head down and don't draw attention to yourself. Just stay about your business, do your best to comply with the ordinances as you understand them, and just don't draw attention to yourself. The other thing I would say is, regardless, make sure that the tenants have access. They have purchased from you the right to have access to a space where they can store their things. So even if you've got to limit what's going on in the office, taking in new customers, whatever it may be, please make sure that those tenants who have already rented units can still have access to their units, because that's critical. That's what they bought, and if we fail to do so, then we run the risk of being accused of having breached the contract with them because they don't have reasonable access. So that's my suggestion on essential businesses. May I still have a lien sale? Well, I don't know of any statewide prohibition, but of course the governor's order, including the current stay-at-home order until May 3rd, and then the show me strong opening order will still apply. So you need to make sure you keep that 6 feet between customers, but you're going to have to check your local. You're going to have to check your local orders to see if you're subject to a mandatory closure order. You may not be able to have an on-site auction. just because you're shut down. On the other hand, even if you aren't allowed to open, you could still have an auction online. You could still look at private sale kinds of sales. So for example, if you had opened a unit that was delinquent and there's an antique piece of furniture in there, even though you may not be able to have an on-site auction, you might well call a half a dozen antique dealers in your community to see, hey, what would you give me for this? In which case you could have a private sale, which is permitted under our statute. Now, I would suggest to you that you consider very carefully whether this is the time to be having a lien sale or not. Now, as we begin to get back into more normal business, this becomes less of a consideration, but certainly in the depths of the COVID-19 shutdown, it was a very real issue. And that is, when people are facing hard times and difficult situations thrust upon them in short period of time, is this really when you want to be selling all of their earthly possessions? That's a business call for you to make. I am just mindful of a situation in St. Louis probably 10 or 15 years ago when we first went to war in Iraq. There was a soldier who had rented a unit. He was on active duty. The facility operator had received a waiver under the Servicemen's Civil Protection Act or Civil Service Act, and so they were perfectly free to have an auction. They had every legal right to have an auction. And unfortunately, the bad publicity was such that they were overwhelmed, and they ended up paying this soldier for the value of his property, even though they had every right to sell. My point here is, be mindful of the publicity. Maybe this isn't quite the right moment. Maybe you want to wait a little bit longer. But again, that's a business call for you to make. May I delay a pending sale? I already have one scheduled. Yes, you can always delay a sale. As you know, under our statute, if you have a delinquent unit, you send that first notice, which says, hey, you didn't get your rent. Please stop by and make good on this. And then more than 10 days later, you send the second notice. That's the one that has all the specific language that you have to have in it. And that's the one that sometimes trips people up if you're delaying a lien sale. If your second notice said, if you don't pay by a specific time, then we're going to sell your stuff on June 2nd, a specific date. Well, if you have to change that specific date, you're probably going to have to send a corrected notice. On the other hand, if your notice says, if you don't pay, then we are going to have a sale of your property after a specific date, which, by the way, is what it should say under the statute, then you don't have to send a corrected notice. Why? Because you're just selling. You're still selling after the specified date. You don't have to send that notice over again. But if you do a set a new sale date, please remember you will have to run that ad again at least 7 days before the new sale date. And that includes if you had already run your ad for the original sale date. You will have to run that ad again before the sale. Now, the last thing on here is not something that's actually required, but I think it's the best practice. If you're going to change a sale date, reach out to the tenant and let them know. It's not required under the statute, but I think it's best practice. Why? Because as we know, the tenant has a right to redeem his or her property from a lien sale up until the moment the gavel falls and the auctioneer says sold. So as a result, if you're going to extend the sale date, then they have more time to redeem. And so make sure they know that, and because you'd hate to run into a situation where a tenant comes back at you and says, well, I thought the sale was going to be on June 2nd, and it didn't end up being until July the 3rd, and in the meantime, I got my tax refund check, and I could have redeemed my stuff, but I didn't know. I would just recommend let them know that it's been extended, and who knows, you may be able to, in that next opportunity, you may be able to work something out with them. So that's yes, you may delay a pending lien sale. May I raise my rent while the state is under a disaster declaration? Yes, you certainly can, but please be very careful. Under the law in Missouri, it is unlawful to charge an excessive price for any necessity within a disaster area. This is called the price gouging rule in Missouri. And since May the 27th or March the 27th, and shortly thereafter, the entire state of Missouri has been declared a disaster area as a result of the COVID-19 crisis. As a result, this rule comes into play. Now, we're not told what's excessive. We're not, and necessity is not clearly defined to include self-storage. But let me just suggest that if push comes to shove and you're arguing about that, my guess is sympathy is going to lie with the tenant and not with you. So I would just recommend that you not look at raising those rents at this point in time. You certainly don't need that hassle of having to deal with this in court at this particular moment. And again, as the state gets back to more normal operations, then we may see this lift a little bit. But again, it is a business decision for you to make. Just please be careful as you do it. May I charge a late fee? Sure, you are authorized by law to have charge a late fee by statute. And I'm not aware of any statewide order that prohibits it. And certainly I've seen nothing in any of the local orders that I've reviewed that prohibit it either. So you may still charge your late fee. And again, the price gouging rules would apply if you raise your late fee. But again, I think if you were to stay within that statutory safe harbor, the greater of $20 or 20% of the rent per month, then I think you should be fine. You shouldn't be in the price gouging range either. But for the reasons noted, this may not be the best time to raise your late fees. Now, I've been asked the question: can I waive a late fee? Or ask another way: can I waive a late fee for one person without doing it for everybody? Well, the answer to that is sure. You might well find somebody who's got a hardship situation, particularly where you want to give them some relief and help them out and not charge the late fee. You're welcome to do that. Or you may have somebody who with whom you're dealing, and you may want to say, look, if you'll get me paid by such and such a date, I'll waive the late fee. Sure, you always have that right to do so. The only way you could get into trouble with forgiving a late fee, waiving a late fee for some people and not others, is if you're doing it for a discriminatory purpose. So if for whatever reason you're some sort of warped and twisted human being who doesn't like Albanians, if you were to say, well, I'll waive late fees for everybody unless you happen to be Albanian, well, that would be discriminatory because you're focusing on a particular group of people and saying, I won't help you out, but I'll help everybody else out in the world. So as long as we stay away from discriminating against, groups, protected groups, then yes, you can always say to somebody, I'll waive the late fee. That's always within your purview. So that is the situation with regard to COVID-19 right now. So again, the primary takeaways are: check out your local rules, because they will govern you. But certainly it appears that we're beginning to open back up, and that's good news for all of us. Now, I was asked a few months ago to let's change gears and talk about the model rental agreement. It had not been updated for a while. This is actually version 3 of the model rental agreement for those of you who are following. This new version reflects changes to the self-storage statute that have been made since 2014. You may remember we had a substantial change to the statute in 2014, and this reflects those changes. The form itself looks much the same as it always has. It still has some most of the same bells and whistles in it. You might want to remember paragraph 30, which allows you to add additional terms if you choose. That's free for you to do. Paragraph 31 still lets you have separate rules and regulations unique to your facility that you can make a part of the contract by simply posting them. So that is still there. And also remember, this is copyrighted material. Paragraph 35 makes that clear, and we sure don't want to have anybody run afoul of that. So what has changed in the new version? By the way, in the slides you're going to be seeing, things that show up in green are new additions to the contract. The black is what's already there. So the first thing here deals with third-party ownership. You may remember that for years we've always had in our statute that the tenant must tell us about any lien holders on property stored in the unit so that we can send notice to them in the event of a default. In 2014, the legislature added property owned by third parties that are stored in the unit, and they also get at least the first notice. What does that look like in real life? Well, for example, if I went and bought a new dishwasher at Sears to put in a new house that I'm building, and until I'm ready for it, I'm going to put it in my storage unit. Well, probably if Sears is financing that dishwasher for me, they have a lien on it, and it's also going to be stored in my unit. So technically, the tenant should be telling us, hey, Sears has a lien on the dishwasher that's stored in the unit. Third-party owners would be, for that new house, I've also rented some new living room furniture that belongs to Rent-A-Center, but until I need it, it's going in my storage unit. Well, that's a third-party owner of stored property. The tenant should be telling us about that. The reason for that is third-party owners are entitled to receive that first notice of default when you send it to the tenant. Similarly, the lien holder is entitled to the first notice and the second notice and when you start providing notice of a lien sale. It also makes it clear that it's up to the tenant to update this information if it is the case. We put this in the unit or in the model rental agreement because it becomes a handy place to collect this information as you're checking somebody in, and it's a go-to spot for you to look if you start sending lien notices so that you can find out where it belongs or who gets a notice. We did make some changes in the rental agreement, in the vehicle trailer addendum, and the marine property addendum, and basically it deals with a tenant who does damage to the property, to the facility. And just to give you a hypothetical, imagine you have a tenant who's a good tenant, pays regularly, but she's driving her car or his car in the facility and runs into your building and damages the building. And then comes into your office and says, I'm really sorry I ran into your building. Here's my insurance company. They'll take care of it. Meanwhile, the tenant goes back to paying their rent, and they're current under the rental agreement, but you get the runaround from the insurance company. They don't want to pay. They don't want to do this. They want to lowball the cost of repair, all of those kinds of things. Well, that leaves the operator of the unit or the facility kind of in the lurch. What this says is, if you damage the property, then you agree to pay on demand the cost to repair the unit or the facility. Why is that different? Because as we know, when you fail to do something in a timely fashion under the Missouri Self-Storage Statute, you're in default. And once we have that tenant in default, then we have all of the remedies that we ordinarily have when somebody just fails to pay their rent. I can lock them out. I could even theoretically have a lien sale. What this does is avoid the situation where the tenant sort of shrugs and says, it's really not my responsibility. It's up to my insurance company. Oh, no, Mr. Tenant. It's still your obligation to make sure this gets paid. You go put the pressure on the insurance company if you need to, but we have the remedies that are available to us as self-storage operators. The rental agreement, as you know, is a month-to-month rental agreement. And under the law, to terminate a month-to-month rental agreement, you usually have to give one full rental period's notice, basically 30 days. We like to be able to move people out sooner than that. So if they're in default, we want to give them 3 days notice and have them vacate. If they're not in default, but we want to get rid of them anyway, at least 15 days before the end of the term. Missouri law has made it clearer recently that you can waive by contract the longer notice period that was required under Missouri law. So what we're doing here is just making it clear that everybody understands I might be entitled to a longer notice period under the normal statutes in Missouri, but I have agreed to waive those longer periods of notice in favor of the shorter ones. So it's just a matter of bringing us more favorably under the existing law. Also, you'll notice at the bottom there, instead of referring to these people as trespassers, we talk about unlawful detainer, because that's probably the remedy you're going to use if you send this kind of notice and somebody doesn't get out. That's how you would get the machinery going in the county to have the sheriff come out and put you back in possession. So that's a change to make it more favorable to us. This last change on the rental agreement just makes it clear that since 2014, we've been able to send notices by email, and this certainly brings us up to date in that regard. Finally, in the vehicle addendum and the marine property addendum, we ran into a situation where we've always been able to move a vehicle or a trailer or something like that on 3 days' notice if it was for reasons of safety or maintenance. There was a situation where we needed to move some vehicles because we wanted to build a new building where these things had been stored, and we could not get the tenants to respond and help us out. So this just says, look, if I'm getting ready to do construction where your vehicle happens to be parked and I've contacted you, given you 3 days notice, and you still won't respond or do anything, then we can in fact move the trailer at your expense, incidentally, Mr. Tenant. So that's really what's going on with the new model rental agreement. As I said, it will look and work much as it always has, and but those will make it come closer to where we need to be on the current state of the law. With regard to recent changes in the law, since we last met in August in Branson, not much has happened in Missouri courts regarding self-storage, but there is one interesting bill currently in the House of Representatives in Jefferson City, and it's House Bill 1966. The first point on the slide there is the existing rule, which says, hey, 7 days before a lien sale, you need to publish an ad in a newspaper. Well, what the change that this bill would make to not only our self-storage statute, but a host of other statutes across the state is to say that at least 7 days before your sale, you must post the notice of the sale on the front page of your facility website if you have one. And if you don't have a website, the Secretary of State will host a public website where for $10, you can post your notices there. So, I mean, this would be a huge help to us because, as we know, it's getting harder and harder to find local newspapers in which to run the ad. It's as more and more newspapers fold or don't publish as often as they used to, it's becoming harder and harder to do that across the state. Now, you can expect huge pushback on this from the newspaper publishers across the state. Why? Because you're hitting their bread and butter at the very time when they're struggling. So do I think this is likely to pass this session? No, but I think at some point in the future, this is the direction we're going to have to go. So at some point, the association, our association, may want to think about lending our shoulder to this to the wheel on this and see if we can't get something done that would make it easier for us to have those lien sales. Finally, I have a few questions, and I'll try to answer those. I've got about 7 minutes left, but I had a question about how do you sign a contract, a rental agreement, when the tenant is a company, and why would you want to do that? First of all, well, companies can only operate through people, through their personnel. Personnel changes, they come and they go. At times when you still want to keep the company as the tenant. A lot of times I've seen this come up where you have a pharmaceutical sales rep who wants to store maybe promotional information, promotional supplies, maybe sample, maybe things like that in a unit, but they belong to the pharmaceutical company, not to the individual. Well, you in those situations would prefer to have the company be the tenant. Well, how do you do that? Well, first of all, somewhere at the top of your lease, you identify who is the tenant. In that space, you want to make sure you're identifying the you're identifying the company as the tenant. Identify the company as the tenant. Now, there will be the representative of the company who's actually standing at your counter. You may want to add that person as an alternate so that you've captured the information. And clearly, if you're using the model rental agreement, a company does not have a social security number, a company does not have a driver's license number, a company does not have a birth date. So you just wouldn't collect that information for the company, although you might want to ask for that from the representative of the company who's standing there. Now, but certainly the contact information, where you're going to send notices, you want to get that for the company if you can. When you get to the bottom of the lease where people sign, the way you sign that to bind the company is you write the name of the company, the Masters Law Firm PC. Below that, you put the word by, B-Y, Stan Masters, I sign, and then behind that, you put the capacity in which they're signing. It's president. Now, I'm sorry I didn't get a slide made of this. If you need more information about this, email me. The email's on the screen there, and I'll happy to send you an exemplar of what this looks like. But basically, it should say the name of the company, by Stan Masters, it's president. That's the way you bind the company. Now, I had another question about the use of e-signatures. Am I comfortable with using e-signatures? Well, I would say yes. Under Missouri law, of course, we have a statute that says the enforceability and viability of a contract or a signature cannot be denied in a Missouri court because it's electronic. So an electronic version is as good as a paper copy. But there are some things you need to be aware of, okay? For that electronic contract to be enforceable, it has to have been entered by agreement. Simply means you can't force somebody to enter into an electronic contract if they don't want to, okay? And that's true of you, and it's also true of the tenant. Also, the tenant who's signing an electronic contract must be able to either print or save that contract. They can't be a situation where they're entering into it, but they have no way of getting a copy for their reference. It has to be available to them. And you have to make sure that there is no forgery going on. You must be able to attribute the signature to the person to whom it is supposed to belong, okay? Now that can be done in a variety of ways, probably through your software, whatever it may be, but obviously you don't want somebody going in and signing just anybody's name to these kinds of contracts. You've got to be able to verify that. The tenant must have an opportunity to correct any errors before they enter into the contract. You may have seen that when you've done that yourself. You just have to say, please look this over carefully before you hit submit. And then finally, the tenant has to know that when they hit submit or enter that signature and press send, that a contract will be formed and they have that last opportunity to abort if they don't want to do that. So what I would recommend is if you're going to use electronic signatures, electronic contracts, that's fine. Please make sure that whatever enabling software you're using allows you to meet these requirements. And if you need some more information on that, I have a handout on it. I'd be happy to email it to me. You can just contact me at the email address on your screen. Let's see, another question I have, how about texting? Can I text my customers? I will tell you that that is a very tricky subject. It's governed by the Telephone Consumers Protection Act. I can't get into all the details today because, first of all, not everybody agrees on its scope. But here's what I would tell you. Before you start texting your customers, and particularly a mass texting of your customers, make sure you have their written consent to do so. That's the linchpin of that agreement. Last question I'll take up here is, can we require a tenant to have an email address? Well, I know of nothing that expressly prohibits you from requiring an email address or refusing to rent to somebody who doesn't have one. I suppose you could do that if you'd like to. But keep in mind, even if a tenant is forced to give you an email address, they can also, under the statute, give you a mailing address. And by saying that's my preferred method, you would have to use the mailing address. So while I suppose you could insist on getting an email address, keep in mind, you may not be able to always use it if the tenant has other ideas. So with that, I appreciate having the opportunity to talk with you. And again, if there is any kind of issue that I can help you with, my phone number and my email are on the screen. So with that, I will go off.
All right. Thank you, Stan. We really appreciate that update. And thank you for getting to those members' questions. We had a few roll in while you were talking, and I will send those over to you via email with the contact information for those who sent that in.
Okay.
And again, thank you. Thank you so much. It's good to have you.
Thank you.